If you're waiting for your green card, or if you work in the United States on a visa, the month of December 2025 brings major changes that could directly impact your timeline and your legal status. From dramatically reduced work authorization periods to new biometric requirements and significant movements in the Visa Bulletin, these updates are reshaping the immigration landscape right now. Stay with me because by the end of this video, you'll understand exactly what these changes mean for you and what steps you need to take immediately. Hello everyone, and welcome back to the channel. I'm diving into something extremely important today, the December 2025 United States immigration updates that you absolutely need to know about. Whether you're an immigrant, an employer sponsoring workers, or someone planning to apply for a visa or green card, these changes will affect you. Let's break down everything you need to understand about the new visa processing rules, green card updates, and policy shifts happening right now. Let me start with what might be the biggest change affecting current immigrants in the United States. Starting December 5, 2025, work authorization periods have been reduced from 5 years to a maximum of 18 months for several categories of immigrants. This is a massive shift that affects refugees, asylum seekers, those withholding of removal, people adjusting their status to get a green card, and individuals covered under the Nicaraguan Adjustment and Central American Relief Act. This change applies to all work permit applications filed after December 5, as well as those that were pending as of that date. The reasoning behind this change, according to immigration authorities, is to increase vetting frequency and ensure more regular security screening of immigrants working in the country. What does this mean for you practically? If you're in one of these categories, you'll need to renew your employment authorization document much more frequently than before. This means more paperwork, more fees, and more frequent interactions with immigration services. Speaking of fees, the cost for applying for work permits has increased significantly, with initial employment authorization now costing $550 and renewals costing $275. These combined changes create both a financial and administrative burden for immigrants trying to maintain their legal work status in the United States. Now let's talk about the December 2025 Visa Bulletin, which brings some positive news amid all these restrictions. The Department of State has confirmed that for December 2025, both family-based and employment-based applicants must use the dates for filing chart. This is significant because it allows people to file their adjustment of status applications earlier in the process. For employment-based categories, there's been notable movement. EB2 India has advanced to May 15, 2013, while EB2 China has moved to June 1, 2021. The biggest gains came from EB5 investor visas, with China advancing 7 months and India advancing 5 months. For family-based categories, there's been progress as well. Mexico's F1 category advanced 3 months and Philippines' F4 moved forward 4 months. If your priority date has become current or is approaching the filing date, this could mean you're finally able to move forward with your green card application after potentially years of waiting. The key here is to check the official Visa Bulletin regularly, because these dates can shift month to month based on visa availability and demand. Another significant development involves the Employment Fourth Preference Religious Workers category. Legislation signed on November 12, 2025, extends this SR category until January 30, 2026. However, there's a critical deadline here. No SR visas may be issued overseas or final action taken on adjustment of status cases after midnight January 29, 2026. And all individuals must be admitted into the United States no later than that date. If you're a religious worker or an organization sponsoring religious workers, you need to move quickly to complete your applications before this deadline. The Diversity Visa Program has also seen changes. The DV 2026 annual limit has been reduced to approximately 52,000 visas due to allocations for other programs. This reduction from the usual 55,000 means more competition for fewer spots. Additionally, the State Department has announced it's implementing certain undisclosed changes to the upcoming diversity visa entry process, though these changes aren't expected to affect the actual visa application period for those already selected. Here's where things get more restrictive, and this affects a significant number of people. Immigration applications from 19 countries designated as high risk or under travel bans have been paused. This freeze affects green card holders and citizenship applications from these countries. Additionally, all pending green card applications for refugees who arrived between January 20, 2021 and February 20, 2025 have been placed on indefinite hold. Applications from Afghan nationals have been specifically paused, with the government stopping most immigration applications including asylum, parole, visa, and green card requests. There's also been a nationwide pause on asylum decisions. While people can still apply for asylum, they will not receive decisions on their cases until the pause ends. Furthermore, there's now a $100 fee to apply for asylum with no fee waivers available. This represents a fundamental shift because asylum applications were traditionally fee-free, recognizing that people fleeing persecution often arrive with limited resources. Starting December 26, 2025, there's a new biometric collection requirement that affects everyone entering the United States. All non-citizens, including green card holders, will have photos taken upon entry and exit at all U.S. ports of entry nationwide. This enhanced biometric screening is part of broader security measures being implemented across the immigration system. If you're planning international travel, make sure your passport photo meets current requirements to avoid any processing issues when you return. For visa interview requirements, the landscape has become significantly more stringent. Since September 2, 2025, FEOA, J, MAH, LL, and O1 visa renewals require in-person interviews. This eliminates the convenience that many visa holders previously enjoyed when renewing their status. Only diplomatic visa holders and certain Mexican B visa renewals remain eligible for interview waivers. Additionally, previous exemptions for children under 14 and adults over 79 from biometric collection have been removed. If you're an employer sponsoring H-1B workers, there's a massive financial change you need to know about. A new $100,000 H-1B proclamation fee is required for every H-1B visa petition filed on or after September 21, 2025, but only under specific circumstances. This fee applies when the beneficiary is currently outside the U.S. and doesn't have a valid H-1B visa, when the underlying petition requested consular notification, or when USCIS approved the petition but denied the status change. The good news is that extensions, amendments, and renewals are exempt from this $100,000 requirement. On a more positive note for certain employers, the H-2B non-immigrant visa cap has been increased by up to 64,716 additional visas for fiscal year 2025. These supplemental visas are specifically available to U.S. businesses that can demonstrate their suffering or will suffer irreparable harm without the ability to employ all the H-2B workers they've requested. The supplemental visas will be distributed in several allocations throughout the fiscal year to accommodate businesses that need workers with different start dates. There's also important information about public charge considerations. USCIS has reaffirmed its policy that immigration officers must look at all circumstances when deciding if someone may become a public charge. This means they'll consider factors like age, health, family status, assets, financial resources, education, skills, and any receipt of government benefits. While this isn't a new policy per se, it's being enforced more strictly, and it can significantly impact green card applications. For those currently in temporary protected status programs, there have been terminations. As of October 3, 2025, TPS has been terminated for Afghanistan, Cameroon, and Haiti. If you're affected by these terminations, it's crucial to consult with an immigration attorney immediately to explore alternative pathways to maintain legal status in the United States. Looking at processing procedures, the Department of Homeland Security issued a final rule on October 30, 2025, ending the 540-day automatic extension of employment authorization documents for eligible applicants who timely file renewal applications. This is particularly concerning because as of November 3, 2025, more than 900,000 EAD applications were pending with USCIS for more than 6 months. Without the automatic extension, employees could lose work authorization while waiting for USCIS to process their renewals, potentially forcing employers to terminate valuable workers through no fault of anyone involved. For green card holders from the 19 countries under enhanced scrutiny, USCIS will re-examine already approved green cards and apply stricter security checks to new applications. This unprecedented review of previously approved cases creates uncertainty for thousands of permanent residents who thought their immigration journey was complete. What should you do with all this information? First, if you're waiting for a green card, check the December 2025 Visa Bulletin immediately to see if your priority date has become current. If it has, gather all your documents and prepare to file as soon as possible because dates can retrogress in future months. Second, if you have work authorization that's expiring soon, start your renewal process early, given the processing delays and reduced validity periods. Don't wait until the last minute because gaps in work authorization can have serious consequences for both you and your employer. Third, if you're planning international travel, ensure all your documents are in order, your passport photos meet current requirements, and you understand the new biometric collection requirements that take effect December 26. Fourth, if you're from one of the 19 countries under enhanced vetting or if you're an Afghan national, consult with a qualified immigration attorney immediately to understand your options and any alternative pathways available to you. Fifth, employers sponsoring foreign workers need to review their sponsorship strategies and budget for the new fees, particularly the $100,000 H-1B proclamation fee where applicable. Finally, everyone affected by these changes should monitor official sources regularly. Check USCIS.gov and the State Department website frequently because immigration policy is changing rapidly, and staying informed is your best protection. The December 2025 immigration landscape represents one of the most significant shifts in U.S. immigration policy in recent years. While there are some positive developments like forward movement in the Visa Bulletin and increased H-2B visa availability, many of the changes create additional barriers, costs, and uncertainties for immigrants and employers alike. The combination of reduced work authorization periods, enhanced vetting procedures, paused applications for certain countries, and eliminated exemptions creates a more complex and challenging environment for anyone navigating the U.S. immigration system. That's everything you need to know about the December 2025 United States immigration updates. These changes are already in effect or taking effect very soon, so it's critical that you understand how they apply to your specific situation and take appropriate action. If you found this video helpful, please give it a thumbs up and subscribe to the channel for more immigration news and updates. Leave a comment below letting me know which of these changes affects you most or if you have questions about your specific situation. Remember, while I provide information here, every immigration case is unique, and you should consult with a licensed immigration attorney for advice specific to your circumstances. Thanks for watching, and I'll see you in the next video with more important immigration updates.